On the schedule, we have a coffee break now, but I think I'm going to take, Tamar and I took an executive decision to skip it now and then have a poll later whether we want it between the next two papers, just because a lot of people join now and we are actually on schedule. So we're going to keep going, and I hope it's okay with you. And I apologize for anyone who was really waiting for this break. So without further apologies, I am going to move to our final panel, which is about secrecy and informality, issues that were kind of, I think, possibly mentioned almost in each and every panel, and that all of us as researchers are handling when we try to research BLAs. So we're going to start with Tamar Megiddo, the fabulous co-organizers of this conference. She's from the College of Law and Business and from TraffLab, and she's going to be discussing with us secrecy and non-bindingness. The discussion will be Adam Chilton from the University of Chicago, who needs by now no introduction. So Tamar, the floor is yours.
Thank you very much. So let me start by saying how much I really enjoyed these past 3 days. When we started discussing in TraffLab the need to generate more, this is running away from me. I don't know why it does that, but that usually means I have to start sharing again, so apologies for that. Okay, so when we started sort of talking about the need to generate more research about BLAs in TraffLab about 2 years ago, I could never have imagined that we would be able to sort of sit in a room with almost everyone we've read on the subject, either as a participant or as a presenter or as an audience. And it's been a real privilege, and I want to thank everyone for doing this. So this paper was born out of confusion. My entry point into the study of bilateral labor agreements was through international law research. I'm an international lawyer. And a little over 3 years ago, I sat in this actual conference room in the law faculty in Tel Aviv in what I think was the first TraffLab event. And I listened to Jennifer talk about regulating human supply chains, and to Yehel and Hila and others talk about that. And the issue of bilateral labor agreements came up. And I was just completely shocked that there was this huge chunk of the global economy and of international law that was regulated in this way, and that I had absolutely no idea about. Now, these were the heydays of the Trump administration, which had a declared policy of minimizing multilateralism and striving for bilateral regulations of various aspects of international relations, and especially on economic issues. And of course, with Brexit in the background, this seemed to be building onto a global trend towards pull away from multilateralism and renewed authoritarianism, but also nationalism. And so I became intrigued with this issue of bilateralism. So I've written this first paper that's yet unpublished for TraffLab, where I compare bilateral labor agreements to bilateral investment treaties. But these are not the only forms of international law that are regulated bilaterally, and we've already mentioned tax agreements and trade agreements, and there are others. So why am I telling you this story? I'm telling you this story because there was one thing I just couldn't get when I got into this issue of BLAs, and that was everyone kept referring to BLAs, bilateral labor agreements, and MOUs, memoranda of understanding, and referring to them in distinction, and I couldn't wrap my head around this distinction. Now, you may ask why that is so complicated, and so here is why. The reason is that the formal position of international law is that there are no such things as non-binding agreements. So just to give one example, Article 1E to the 1969 Vienna Convention on the Law of Treaties stipulates that a treaty is any international written document that reflects the agreement of two states on an issue governed by international law, whatever its particular designation. So if it's a treaty, and it's written, and it's between two states, and it is on international migration, which is an issue that is covered by international law, then it is a legal binding treaty, and it doesn't matter whether it's called an MOU or not. Now, the International Court of Justice has also opined on this, and just recently has found an MOU, not on labor migration, but on a continental shelf bordering between Kenya and Somalia to be a valid binding agreement, even though it was designated as an MOU. So the court looked into the agreements reflected in the treaty to try to stipulate whether they were binding or not, what the way that the parties formulated their agreement, but the title didn't mean anything, in fact. Now, if it is a treaty and it is binding, then a state that breaches its obligations under this treaty could be held internationally responsible and may be required to make reparations for the breach. So now you may say, okay, so maybe the title doesn't matter, but these documents could also reach this softness otherwise, right? They could use language or mechanisms that are soft, that don't reflect a binding agreement, by using aspirational language or avoiding concrete rules or not including any enforcement mechanisms. But as far as I have been able to learn, the scholarship doesn't show us that this is necessarily the case. Rather, designation as MOUs is perceived as the sort of the key indicator for a treaty's informality. Now, if I read, for instance, Maggie and Tiana's paper correctly, when they code for informality, they look at the paper's title. And I think it would be worthwhile to sort of dig more deeply into the text of these treaties and try to create an index for formality or informality, hard, soft, binding, non-binding, that relies on the provisions in the text and the mechanisms created in the treaties to really account for whether they are indeed formal or not. And Adam, to your suggestion in the first day, maybe this is something you would like to sort of include in your coding project. So from my more anecdotal and admittedly not systematic reading of VLA's MOUs, many MOUs seem to not be that different from VLA's. So if you take just as an example, these two agreements, one is an MOU between the Philippines and the United Arab Emirates, and the other is a formal BLA between the Philippines and Germany on health professionals. The MOU doesn't contain any softer or more hortatory or more tentative language than the second one. They actually are quite similar. They have address the same issues. They have very similar provisions, the same mechanisms, the same sort of how screening is done as recruitment and what rights workers may have. And they have to go back after their visa has ended. And there's a joint political committee, and there's talk about the entry into force and the renewed force of the agreement thereafter, et cetera. So it seems that we have tended to sort of take at face value states' claims for informality just because of that designation, but we haven't paid, I think, enough attention to the fact that these documents often contain texts that are highly similar, and that in terms of the international law doctrine, legally, they are exactly the same. Another point is that, as many of us have already noticed, VLA's informality is coupled with their prevalent secrecy. So we've discussed the difficulty of obtaining hard copies of VLAs, and we've sort of eagerly have added up the numbers of documents that we have been able to get a hold of out of the number of papers we know exist. But we also know that we don't necessarily know, right? There are, to anyone who's in this room, it is quite clear, I think, that there are a not insignificant number of VLAs out there that we don't even know of, not because they're just inaccessible, but also because they are secret. Now, in this context, it may be helpful to mention that unlike informality, international law doctrine doesn't formally ban secrecy. There was an attempt to do that in the League of Nations in the beginning of the 20th century, but I think it's fair to say that this attempt failed. And what we do have now is sort of a call on states to register treaties with the UN Secretariat, which will then publish these treaties. But there is no sanction sort of added to that. It's not that treaties that aren't registered or published are null and void. They're not invalidated. They are just, the states just cannot then rely on these treaties when coming to UN organs. So they can't ask for their assistance in enforcement, for instance, or otherwise. Now, I won't get into the reasons for states' choice to conclude secret informal treaties on labor migration. That's Maggie and Tiana's paper that we'll hear next. My paper adopts or asks this critical normative question on this practice. So why should we accept that this is legitimate? And is this claim to informality and secrecy a valid claim? So in this, my argument is briefly that we should not accept that and that it is not a valid claim. And I think this is the point where the issues of bilateralism and informality and secrecy come together. So the way I think about it, international agreements can be placed on the scale between treaties that are more contract-like and treaties that are more similar to lawmaking. And generally speaking, bilateral agreements are closer to the contract end of the scale. And this is more so, especially when they regulate issues that are strictly interstate, that are strictly between these two entities that are states. Now, generally speaking, again, multilateral treaties are closer to, as a rule of thumb, closer to the lawmaking end of the scale. And this is especially the case when they create rights and obligations for third parties that are not, were not part of the negotiation or the drafting of these agreements, but the agreements nevertheless guide their behavior and create such rights and obligations for them. Now, lawmaking type agreements, I argue, should be held to a high publicity standard. They should be expected to be public. And the reason is that these third parties whose actions were the audience of these rules have a legitimate minimal expectation that is firmly grounded in rule of law considerations, that the document containing these guidances for them will be accessible, available, public, so that they can learn of their rights and obligations and they can orient their behavior accordingly. Now, I think, for instance, that, or let me say one more thing beforehand, in international literature, there have been several pieces that have sort of defended secrecy of specific kinds of treaties, for instance, defense treaties, and sort of explaining that there are circumstances where having these kinds of treaties secret would be legitimate. And my reading is that these justifications work for these treaties that I said are closer to the contract end of the scale, like defense treaties or weapons treaties. But I don't think they justify secrecy for BLAs as much as for BITs, bilateral investment treaties, or human rights treaties. And the reason is that these kinds of treaties inevitably create rights and obligations for these third parties that I mentioned. And I'm not just talking about migrant workers, but also recruiters and employers and other third parties to whom they create rights and who are not part of the negotiation or drafting of the agreement. And if these treaties remain secret, then these people they cannot mind their obligations, they cannot realize their rights, and they also cannot challenge the legitimacy of these documents or the validity of these rules that are that aim to guide their behavior, whether on flawed process or flawed content through the various channels available to them nationally or internationally. One final note before I conclude. I think that BLAs are lawmaking-like and rights-creating, even if they are completely silent about human rights. So even if all BLAs do is say, the countries agree that workers from one country can come into the other country and they have to leave when their visa is out, and there is nothing said about their rights during employment or during residence in the host country, they still, I think, should be placed at the lawmaking end of the scale. And the reason is that this should be seen as a lacuna, because bilateral labor agreements, almost by definition, are about the rights of these individuals, not only the workers, but also other individuals and bodies involved in labor migration. And they set the terms under which they can travel and live somewhere and work, and they set obligations for workers and recruiters, and require that workers leave when their visa is done. So they too, for this reason, should be held to a high standard of publicity and should be required to be public. So just to conclude, I see no reason why we should sort of buy into this BLA MOU claim for informality. And I think that none of the defenses that are offered in the literature, which I talk more about in the paper, can justify the secrecy of bilateral labor agreements. That's it. Thank you.
Thank you, Tamar, for really attacking this big elephant that's in the room the whole time, the issue of secrecy and non-bindingness. And we've a lot of us are using BLAs and MOUs interchangeably, and I think you give us a strong justification to do that. So now we'll move to the discussant, Adam Chilton.
Thank you. So thanks, Tamar, for the paper. The paper, as I understand it, is making essentially two kinds of arguments. The first argument is a descriptive argument to describe the secrecy around BLAs, and then the attempt by countries to label or informal instruments. So this is a sort of descriptive account of these two features of the BLA regime. Then the second part of the paper is essentially a normative piece that's trying to evaluate the validity of these two moves and think about whether or not we should be okay with this or whether or not these moves are justified. I wanted to say a few things about each of this, the descriptive piece and then the normative piece. First, on the descriptive piece. Right now, one of the key pieces of the descriptive part of the paper is discussing the secrecy regime around BLAs. I actually think maybe a better way to frame this is the lack of transparency instead of the secrecy. So the secrecy implies that there's an explicit attempt by states to not make their agreements public. Now, I assume that that is happening some of the time, that there are some agreements that are signed in secrecy the same way that arms trade agreements are signed in secrecy. But I think in other cases that states are just lazy and don't bother to report them because they signed some agreement at a summit or whatever, and it just gets lost. In other cases, they are reported, but they're just forgotten by time. In other cases, they're actually public. It's just that those of us in the room don't speak the right languages or know the right places to look or whatever else it may be. And so I think that there's all of these different mechanisms that add up to a regime that's just really tough to get our arms around. Now, I agree, secrecy is one piece, but I think that the lack of transparency is a broader problem than just the states keeping them secret in the way that the paper talks about, for instance, Ashley Deek's research that is focused on like the United States' treaties that are explicitly secret and that we don't make public. And so I think transparency might be the better frame for this kind of argument. Second, the paper right now, while making the descriptive piece, there's a lot of work to document the costs associated with secrecy and informality. For instance, that people can't leverage these agreements or know about their rights, or there isn't a race to a top, et cetera. The descriptive piece, however, does less work to try to explain why there may be benefits. And here's what I have in mind. For the host countries, announcing that you're going to let more migrant workers in is typically extremely unpopular, or that you're going to be giving them more rights or more regulations, et cetera. At least it can be unpopular. If it's the case that doing these agreements in less public ways can increase the rights of migrants or increase net migration, that would be a good thing. Now, I don't know if that is what's happening or what it's not, if not what's happening, but it's at least worth thinking about whether or not these features of the regime advance the goals of increasing migration or the rights of workers or the formality of workers, et cetera. That is, it's worth looking at least for some of the benefits and just of the costs. Third point on this descriptive piece. As the presentation just now made clear, the paper sort of formally focuses on secrecy and informality of the agreements and the non-bindingness of the agreements. But the third kind of argument about the agreements that comes out again and again in the paper that also came out in the talk is the enforcement mechanisms, or the ability of states to actually enforce these agreements through binding ways. And this is, a clear contrast to, for instance, the bilateral investment treaty regime that has investor-state dispute resolution that creates a forum for countries that have their rights violated to specifically bring a claim, whereas that kind of forum isn't really present in BLAs. So I think it's really three features that should be highlighted all at the same level, which is the lack of transparency, the attempt of the informality or the non-bindingness, second, and then third, the enforcement proceedings. And it's, I think all three of these features are discussed in the paper, but should be put on equal footing. All right, now to the normative piece. So the paper then moves on to arguing whether or not the secrecy and the informality is valid, and should we have a problem with it. And the paper essentially argues that this is problematic because a variety of reasons, that you can't appeal to the United Nations, that people don't know about their rights, that you don't have a race to the top, and that maybe this could work for some kinds of treaties, but for this kind of treaty where you're creating third-party rights, it just doesn't really work to have this claimed informal secret agreement. And it's right. Here's, I think, my concern with this normative argument. I think that there are a lot of unstated premises that are required for you to make this normative claim, which is essentially, I think what you're assuming is that, like, in your mind, or the paper's mind, it seems to have in the background, like, the goal that states should be achieving is like advancing the rights of workers, and signing treaties in this ways does not accomplish the goal of advancing the rights of workers. Therefore, it's normatively problematic. If instead what we assume that the goal of governments is to promote the rights and welfare of their citizens, this might be an extremely useful way to accomplish that goal normatively, right? So if the goal of the United States or the Philippines or whatever is to make the citizens of the United States better off, this might be the exact best way to do it. And so when making normative arguments about international law, I think you need to say what the normative premises underlying this are. Now, in part, this is problematic because normally when people make normative arguments about international law, they take this form of, like, you've committed yourself to this human rights treaty, to this trade regime, to the WTO, whatever, and now you're not living up to your agreements, right? Therefore, because you bound yourself, it's normally problematic to not live up to your international commitments. But here, the first half of the paper is explained that states are sort of bending over backwards to not bind themselves to many of these things. So it's sort of weird to say that it's normatively problematic to try to not make a promise and then to not live up to the promise you tried to not make, right? So really what is being sort of spun as a normative argument about informality is really just an argument about how this isn't the most effective way to accomplish improving the goals of labor migration, which I think is a fine argument. I agree with you. I wish that these things were binding, transparent, clear, enforceable, et cetera. But that's because I'm very clear that I want more migration and more rights for the workers, et cetera. So I think you could just reframe this and say, this is why often the BLAs fail workers, et cetera, but not to instead sort of frame it as a normative argument about informality, right? Which I think are slightly distinct claims. Anyway, all of that said, I thought this paper was really great. It's really interesting, and it sort of foregrounded these two issues that all of us mention in our papers, but never actually take the time to think through. Why is it secret? Why don't we call these MOUs? Does it matter, et cetera, and brings in a lot of detail and facts, et cetera. And one final point on this, the pairing of this panel with the next paper, Maggie's paper, is great because it's, right on the same topic. And one other thing that this paper may be able to do is to think about generating more specific predictions or hypotheses that papers like the next paper on the panel could test in the future, because I think this paper has done really a lot to think about these features of the regime in a way that just hasn't been done before. All right, thanks a lot. I'll stop there.
Thank you so much, Adam. So now we'll give Tamar the opportunity to respond, and then we'll take questions. So Tamar.
Great. So let me just say thank you very much. I'll just take a lot of this on board. I'll just say one thing, which echoes a conversation I think I had with Ilan in a previous session on this paper. And that is, so I'm not deluding myself that states necessarily, or that states do seek to advance the rights of workers through these BLAs. I think often that's at least it's not the main focus on these treaties. And there are developmental issues, and there are issue linkages, and there are other reasons why states may want to enter into a BLA with another state. So this doesn't come from sort of an observation of what they promised and now they fail to live up to, but rather from a sort of a rule of law theory kind of requirement that if you want to make a rule for a person to guide their behavior, if you create a right, or especially if you create an obligation, then you have to sort of reflect that to the person. So that goes to transparency, as you said, or I think maybe the reason I use publicity is the use of this term in rule of law literature. But I certainly need to sort of flesh out the unstated premises and maybe think more about how I engage with that comment. So thank you so much for that.
Thank you. So we'll take questions. Maggie.
There we go. I was doing the mute thing. So one thing that Adam's comments made me think about is there's a new sort of debate in political science around the importance, or let's move back from international law and let's move back from formalization, especially around the trade regime, but also around BITs. But thinking about the ways in which the formalization around the WTO has moved the conversation to these like unelected bureaucrats who don't take in account the views of like the average person. So I wonder if normatively there's like a tightrope here, whereas on the one hand, secrecy isn't great because again, you're not maybe, especially if these things are unpopular, which is what Tiana and I suggest. And I don't think that like increasing immigration being unpopular, at least with some set of the population, is necessarily a controversial claim. So on the one hand, it means if you're secret, maybe you can get more of these done. But on the other hand, it might lead to more future backlash. So I just want to throw that out there as an idea of like this trade-off of like, you could get it done today, maybe if it's more secret, but maybe it leads to more backlash. And I'm going to put a paper in the chat that I was thinking about when Adam made his comment for you just to take a look at. That's about the trade regime, but maybe it's helpful.
So I think thanks for that. I think that's right. And I think it also, that's what I was thinking when Adam made this comment, that there's also this democratic question, right? Do transparency is sort of maybe a global governance type requirement to make, and it assumes that even the people of a country where it would be unpopular to enter into BLAs have a right to sort of chime in on the decision. But that would indeed, I agree with you, would probably lead to less BLAs signed, and that's not necessarily a good thing. So there is this trade-off. I don't have a good solution for it, but I need to recognize that, I think, more clearly in the paper. Yeah, thank you.
Thanks. Piacere?
Thank you. Yes, yeah. I must start by saying that I am not a lawyer, so I cannot go into final law points. But I have always been a great advocate of transparency in bilateral agreements and MOUs, because in all my training courses and others, this is one thing we are always advocating. Now the question here, so that way I agree with you. The question is, I mean, do you have any, do you see any pattern, whether it is the countries of origin or the countries of destination, which are more secretive about, these agreements? I haven't really looked into that. The secondly, what I fail to understand is why people don't want to be transparent about these agreements. Because I have actually gone through the text of more than 200 plus agreements, and I haven't seen anything confidential about these migration agreements. Of course, if there are MOUs on military matters, intelligence matters, or trade agreements, you can understand, countries may want to hide it. But if you look at them, they are quite nice words. I mean, because people will be treated in accordance with labor law, these are the responsibilities of the two parties. People can remit their money back home. This kind of statement. The only thing I ever found was this Malaysian agreement. Sometimes they say, with Bangladesh, it said, no worker from Bangladesh may tie the marital knot with a Malaysian citizen. It applies to Vietnam also. This is the only thing. And but still, even Philippines, which is well known for its transparency, recently withdrew all the links to the agreements from its website, but they restored them after a few months. Why? I tried to find out why. It is because some other origin countries were citing articles from this when they bargained, and also some destination countries were also insisting on the Philippines that they should, you agree to this with this country X or Y. So why don't you want to do that? That's why they had. Then other point I want to mention is, I mean, I also agree with this. I also have been giving some thought to this distinction between MOUs and BLAs. Although I am not a lawyer, but I also read something about it. I am also increasingly convinced that the distinctions are marginal. Now, take for instance, in Qatar and Saudi Arabia, they always saying Saudi Arabia all dedicated domestic work agreement arrangements are agreements. Similar with Qatar. Qatar has always been signing agreements, but in practice, I don't see any difference in implementation between these and other MOUs with other countries, UAE and others. I mean, because if you look at the record of Saudi Arabia on domestic workers, although they signed these agreements, from Bangladesh, I mean, Bangladesh women workers, domestic workers, they return after 3 months. I mean, so a large number because they cannot, they are given so bad treatment in spite of the treaty. So it is, and also I would like to raise this question. People say that BLS are binding, legally binding agreements. I mean, is there any case of litigation where any country has, any origin country, any party has actually sued another country for violating the bilateral agreements? In trade agreements, this is you can expect that, but I have not seen anything. Thank you very much.
So thank you very much.
Let's take another question and then have you respond to both. So okay. Jenna?
Hi, folks. So I tend to agree with both Pirsiri and also Adam's points earlier. I think bilateral agreements, whether they're MOUs or agreements, are tools and mechanisms that are primarily used in the interests of states, and their interests are, and we know all that, right? But I think part of it is, what are we expecting them to do? And when you think about it another way, it's about how do we make bilateral agreements work for migrant workers' interests and work for protection? Some sending countries have seen them in that regard. The Philippines is one example, right? They've worked with them to try to get more clauses in them that are worker-centered that are focused on rights protections. But that's sort of, that's not really the intention of these agreements. And so no wonder they, are sometimes not really fitting with overall that agenda, because it's not really their purpose. But I think it's important to recognize that the Global Compact for Migration, all of the lead up to that, and the process of implementation of the UN Network for Migration and the GCM is a strong movement towards using BLAs as the mechanism to govern labor migration that is safe and orderly. And so I think that to me, that signals a move away from those rights-based instruments that already exist around migration governance. And as researchers and advocates, I think we need to be asking the question is so what do we need to do to make bilateral agreements still feed into or support or connect into these normative instruments? So one example I can think of is when I think about how I think we need migrant workers' voices in the process of both determining the scope of BLAs and evaluating them in some mechanism, in some manner, right? And so what other ways? And so I wanted to ask the authors what they thought in terms of how do we start making BLAs work? So what processes do we need in order to have them work for migrant workers? Thanks.
Tamar, you can go ahead.
Okay, so thank you all very much. Let me say, you asked if I see a pattern. Actually, I think the main source of data that I have on the patterns are from your 2015 report for the ILO, where you note that 70% of Asian BLAs MOUs are actually MOUs. And Asian countries are also those who tend more to be not transparent or to keep secret treaties. So that's in terms of the pattern. Why not to publish? I think Maggie will have more to say, but I think she said already. I mean, and Adam said it's quite possible, right, that these are not popular treaties, and the states don't want to sort of deal with the public outrage on generating more incoming migration. But that's just, for me, it's just a speculation. On enforcement, there isn't enforcement of BLAs as much as on trade agreements because they don't allow for such, right? Trade agreements have and investment agreements especially have much stronger enforcement mechanisms, whereas BLAs intentionally don't have them. So that's why we don't see them. But I think if they're public, then they can be a basis for litigation within countries. And we've seen that here in Israel. And I think that's, so we've seen litigation around BLAs. And I think that's a way forward. I want to say something to Jenna about sort of how we're finally moving away from rights-based instruments and why should we be sliding back, and how states sort of. So I think you said something about the intention of states, and I have a kind of a so what answer to you. So what if states don't intend to use these as rights mechanisms? I think at the end of the day, these are instruments that directly and very comprehensively impact the rights of people. All kinds of people who are involved in this human supply chain. And so the fact that states, it's not their intention, doesn't necessarily get them off the hook of having to sort of, at least as a minimal requirement, publish what these requirements are that people have to meet and what their rights and obligations are under these treaties. And so, and this is coming from sort of a rule of law type requirement of any kind of legal document, right? It's often the case that, I don't know, contracts between two firms within a country don't care about, I don't know, the workers of one of the companies, but if they create rights and obligations for a third party, then that third party should know about that. So that's sort of the move that I'm trying to make here. And I guess we're probably time sensitive, so I'll stop here. Thank you all very much.